Good morning. My friend Ramana was right that for the past few days I could not discuss the issues properly because I am not well. Sneezing, cough, headache. Uh, when I usually used to raise 4:30, 3:30, now I can only raise by 6 p.m. Today it's all right. Okay, whatever it may be, I would like to discuss a case wherein these paramilitary forces employees are dealt for their delinquencies, commission of offences, etc., like the border security force, central industrial security force, so many other forces are there. Here is a case very interestingly. Before going to the citations, now I will first discuss about refer the citation AR 2023 Supreme Court 4262 AR 2023 Supreme Court 4262 Union of India versus Jogeshwar Swai. Here actually a doctor stationed as a border security post camp. A constable was deployed as a security for her. She wants the constable to go out of the house because she is going to take bath. Then what had happened, at the time of taking bath, she noticed some cameras were being clicked. She shouted. Her mother searched for no one was available. Thereafter, she lodges a complaint to her superior officer, and the constable was arrested and charged for offence of Section 40 of the Border Security Force Act 1968. Then what happened? They have held the proceedings by Summary Security Force Court under Border Security Force Act. Therein, they have according to the Border Security Force Court, the constable pleaded guilty and he was dismissed from service. Then an appeal was prepared under 117 of the Border Security Act. That the appeal was also dismissed. Thereafter, he filed a writ petition before the writ court, High Court. That High Court allowed the writ and set aside the removal of service. Then Union government seems to have filed a review petition that was also dismissed. Therefore, they went to Supreme Court. Now the question arises, on what ground Supreme Court concurrently accepted the view of the High Court. Number one, they say statement of delinquent. Constable was recorded on the same day when deposition of last witness was recorded. Abstract of evidence was not provided to him and 24 hours time was not given for reflection. Then minutes of proceeding Summary Security Post Court did not indicate that what advice was rendered to him regarding general effect of plea of guilty taken by him. So the court says they ought to have informed him that if he plead guilty, there will be a punishment. And signature was also not obtained from him. Apart from that, this is most important. The camera, suspected camera, was not recovered from the constable, but it was recovered from the neighbor of the lady doctor. And ownership of camera was not proved. And further worst, reel was not developed to confirm allegations. That camera reel was probably so many reasons was that. Therefore, the order of dismissal was set aside. Very interesting case. So you have to see the procedure adopted seems to be harsh. If the proceedings was properly conducted, the delinquent may not succeed. This is what my presumption. This is the way why I am sharing the judgment. First of all, the lectures on the part of the investigation. Here, lectures on the part of the departmental officials in recovering the camera and not able to prove the ownership of the camera, simply coerce him to plead guilty and dismissing him from service without obtaining signature for pleading guilty, and without informing him that if he pleads guilty what will be consequences, and the statement of witnesses was not furnished to him, and 24 hours reflection time was not given. All these areas you can read at the relevant paragraph of the judgment, and this will help you to write your examination. You are proposed to face shortly the successful candidates who are about to write written examinations shortly. Best wishes.